Do you see Kanu regaining his freedom anytime soon?
It's only President Tinubu that can, honestly, in all honesty, give an answer to that question. They can wake up one morning and tell you, see, it's political expediency that will release Kanu. They can wake up any morning and tell you that, and tell the Tinubu can wake up any morning and tell the Federal Attorney General, Minister for Justice, to enter no process against Kanu. And he will simply write the judge. If it's not, if the matter is not coming up, he will just appeal to the court to resume sitting, and he will enter no process, and that will be the end of the matter.
So guys, welcome back to this channel. You know, a whole lot of people have been asking what is next for Nnamdi Kanu after Justice Nyako had dropped the case in previous proceedings in the Federal High Court, Abuja. You know, this has been the question of a whole lot of people after the set dates. And you know, in this video, this lawyer talked about what's next. Is for Nnamdi Kanu, what Tinubu should do and what people should expect that will happen to Nnamdi Kanu and his detention. And he categorically stated that Nnamdi Kanu has no case to answer, that these people are just wasting Nnamdi Kanu's time, that as far as Nnamdi Kanu is concerned, that they are just wasting his time because they believe that nobody in government can stop him whenever he is released. So that is why they are wasting his time and all that. So I want you guys to listen to him as he explains in details a lot of questions people have been asking about Nnamdi Kanu's detention. So watch this video and understand what he's saying. Please, if you are new to this channel, just do well to subscribe, like, and also drop a comment below. I'll see you guys in my next video.
Help us, a lot of people who are not exactly versed in the legal terminologies that are employed here. What really is the issue here? Is the judge not doing the job? Because I could hear Kanu there saying that they are cherry picking the charges they are giving him, that they are changing them. Charges that were filed before, they just change it and file it again. That ultimately that they seem to just be wasting his time instead of giving him a fair hearing. First of all, do you think that they are wasting Kanu's time? And was it the right thing for Justice Nyako to step down on the request of Kanu?
Yes, I agree that they are wasting Kanu's time, because myself, I've also looked at those charges. I've looked at, you know that the Constitution of this country has said that for anybody to be charged for any offense, that offense must be defined in a written law in Nigeria, and the penalty must also be provided in a written law. So if an act which is deemed to constitute, or which is alleged to constitute an offense, is not defined in a written law, then it cannot give rise to an offense, and nobody can be charged for it. It must be defined by written law, and the penalty must also be stated in a written law. Now, if you look at all the acts that Kanu was said to have committed, looking also at the forum competence, that is the court where Kanu is charged, it will be very clear to you that all these charges, legal minds know that none of them can ground any conviction in any court of law in this country. So I agree that they are wasting Kanu's time. Then, if you, in respect of the judge recusing himself, if you look at the Constitution of this country, Section 36, which under the 1979 Constitution was Section 33, and under the Order in Council Constitution of 1960, it was Section 22. The same thing with the Republican Constitution of 1963, it was also Section 22. It says very clearly that in the determination of the civil rights and obligations of any individual, that's civil rights, Section 36, subsection 1. But if you look at Section 36, subsection 2, it also tells you about the criminal rights of any person. In any event, what is important is that Section 36 deals on fair hearing. Section 36 of the Constitution. And when you come to fair hearing, it has two limbs. The two limbs are, one, the first of the two limbs is audio alteram partem, and the second, which means let the other side be heard. So you don't hear just one side and you give decision, judgment. No, you must hear both sides. That's what the first maxim refers to, auditorum pater. Then the second is nemo judex in propria causa sua, that one cannot be a judge in his own cause. The implication is that if the presiding officer has any link, either friendship or blood relationship with the accused person or the complainant or any person that has anything to do with that case, that presiding officer will not handle the matter. By presiding officer, I'm talking about judge or magistrate or even customary court member. The person will not, ought not to. Fairness does not allow the person to adjudicate over that matter. Now, under this, you can talk about likelihood, real likelihood of bias. You can also talk about bias implicita. It is bias when the person has started the matter already and the person has done certain things that shows very clearly that he is biased. Then likelihood of bias, real likelihood of bias is if there are some other things that has taken place or that may not have taken place, but make somebody believe that this judge is likely going to be biased. And that suspicion must be real. It must have some certain things that will show that there is no doubt this person will preside over this matter without being compromised. So in such a matter, in such a case, that judge or presiding officer ought to recuse himself. Recuse, of course, means that somebody who is presiding over something should refuse to preside over it. That is, you've been given something to handle. You say, no, I don't want to handle it. You have recused yourself from such an act, especially. It's usually used mostly in judicial circles. When a presiding officer is demanded not to continue with the matter. So, and I honestly think that what Justice Binta Nyako did was the best any reasonable presiding officer should have done in such a circumstance. Because, look at the reason. The reason is simple. Justice is built upon confidence. And the moment that confidence is not there, that there will be justice served at the end of the day, then there won't be any point for that adjudication to continue. Because if at the end of the day, the presiding officer does exactly what the law has said that he should do, but there's no confidence that what he did was what the law said he should do, then there's no justice. Because, like I did say, it is a universal principle that justice is built upon confidence. So when the confidence is lacking, then proceedings should not continue.
All right, a few other things that Kanu raised in the video we watched. He's saying that for the alleged crimes that he committed in the UK, that Nigerian courts can't try him on them, except, of course, the courts in the UK give them some kind of, that you know how you
yes.
put that the Nigerian courts don't have jurisdiction to do it, except that transfer of jurisdiction was done from the UK. So how do you help us dissect this? Because that's one of the strongest points he made. Before we get to the issues he raised about how the DSS intercepts information from his lawyers and interdicts documents and all that. First of all, respond to the issue of that issue of jurisdiction. The charges against Kanu, the crime allegedly were not committed in Nigeria. That's where the problem is. So his stand is that the Nigerian courts don't have jurisdiction to try him. So is he right in making that assertion?
If you again come to justice, you will see that there are, for any matter to come to court, that matter must be justiciable. By justiciability, I am making allusion to the provisions of Section 6, of subsection 6 of the Constitution of this country, 1999. When, for a matter to come to court, the person bringing the bringing the matter. Okay, first let me say that there are twin pillars of justiciability. Just like you have twin pillars of fair hearing, you also have twin pillars of justiciability. The first is that the person bringing the matter must have the locus standi. Most people are just shortening it by saying locus. So if
I mean, for someone who isn't a lawyer listening, what's that?
Yes, locus standi means the person must have the place of standing, legal standing, to institute a matter. That's when it is civil. And if the person, because that's the first thing the court must look at before the court can proceed with that suit. The court will ask itself, does this man have the locus standi to institute this matter? If the person has the locus standi, the next is the court the forum competent that will handle the matter? That is, these are the twin pillars of justiciability. Locus standi and forum competence, jurisdiction. That's in civil. And now if you come to criminal, like I did tell you, the provisions of section 36, I think it's 10, 11, or 12, subsection in 10 or 11 or 12, where the Constitution said that nothing can be regarded as no act can be regarded as a crime unless that act is defined in a written law as a crime and the punishment spelled out. It is that same written law that you say everything about the crime, where the crime could be committed, where the act could be committed for it to be referred to as a crime. The law will state it clearly. If it is committed in GRA, it is a crime. But if such thing is committed in Obiago, it is not a crime. The law will state all this. But most times the law will tell you if it's committed in any part of this country or if it's committed in the state, if it's a state law. But for the federal law, the Criminal Code Act, or the Penal Code Act, they always tell you the north or the south. So if for what you are dealing with, treason is simply, it could be committed by word of mouth, it could also be committed by an act of anybody. What is important in treason, to make it very clear to the layman listening, is that treason must be an act or something rendered in speech which is geared towards toppling the federal government or doing anything that will bring the ship of state to that is, do anything that will change the government of this country extra legally, outside the law, either by a revolution or by military push, that's a military coup, or any such thing. Anything that is geared towards changing the government violently, not in accordance with the law. That's a treason. It could be by word of mouth, it could be by an act of anybody, and when such thing is done, the person could be charged for treason. But like I did say, the law specifically clearly said such thing has to be done in this country. If somebody did such things outside the shores of this country, I think it would be an uphill task for the federal government, or indeed anybody, to be able to move the court to convict such person of such an offense. Because ask yourself, was there an offense committed? Looking at the definition I've given, was there an offense committed? That's the starting point. So, but well, it may not be very, very good to delve into the intricacies, because in as much as the matter is not before a judge as we speak, it is still a matter in court. It's been struck out in that court. No, not even struck out.
He struck out. The judge just
sent it back to the register.
Chief Justice. So
yes, sent it back to the register.
Okay, so, very quickly, we're due for a break in 4 minutes, but I'd like you to weigh the issue of the role of the DSS this whole time. I mean, if you've monitored Kanu's trial, he's always complaining about the DSS, and this is not, putting DSS on trial. But if you look at complaints of people and the DSS, it looks like there is the government, there is the DSS, there is the court, there is the DSS. when instructions are given from the court, it looks like you would need an extra layer of authority to get the DSS to do those things. They keep insisting from it through his lawyer. He said it there that they used to intercept and interdict their documents and don't allow them some private time with Kanu, which is what the law provides for somebody facing such charges. What's your response to that?
My response is very clear. First, I have never witnessed any of such things because I'm not opportune to be there. And I also do not have any reason to doubt what the Kanu's lawyers have said or what Kanu himself has said. First, the DSS will not respond to it. But of course, I think it will. I can't even conceive Nnamdi Kanu saying what has not taken place, or his lawyer laying unfounded accusation against DSS. So I believe what they said, and I think it's wrong. It's not correct at all. First and foremost, if you know that there are classes of offenses, you have simple offense, you have felony, and you have capital offenses. What Kanu is facing is a capital offense. It's not a misdemeanor. It's not just a felony. It is a capital offense. That's the highest offense anybody can be said to have committed. Since it is such an offense, the state is duty bound to afford him every opportunity. These are things that the Constitution listed down under Section 36. You must give the person every opportunity. You must afford him. That's the word. Afford him every opportunity to prepare his case. If he needs an interpreter, you provide. It is not possible for the person to be said to have prepared his case if he cannot sit in a place that is conducive with his lawyer, where they will be afforded some form of quietness, without any disturbance and without any interference. They have to be there, discuss very frankly. Nnamdi Kanu will speak to his lawyer very frankly and very honestly. His lawyer will tell him the defenses that they can enter into, the ones they will succeed and the ones that may not be successful. So if you don't give him that opportunity to prepare his case as demanded by the Constitution, the implication is that you have the matter has already been prejudged. Right. You have already condemned him before even the court looks into it.
All right, thank you so much. We're due for a break here on the Eastern Eye. When we return, we will find out exactly what will be the next line of action for Kanu, and then who is going to be presiding over the case. Which court will it go to? Join us after the break. You're welcome back to the Eastern Eye here on Afia TV. We are reaching you from Enugu, Southeast Nigeria. My name is Alex Obodo. Still have here with me constitutional lawyer, Honorable Nwabeze. Thank you so much for joining me tonight on the Eastern Eye. So, what's next now for Kanu's trial? Now that Justice Bintayako has recused herself and sent the case file to the CJ. So, who do you think picks it next? And do you think that wherever it wants to go, that there'll be a lineup of judges who are willing to accept that case?
I must be frank with you that it's one of those cases that most judges will not want to touch, even with a 10-meter spoon. Now, it is that of where it goes is the exclusive preserve of the Chief Judge of the Federal High Court, and it's either the Chief Judge does it himself or he allows the administrative judge to do it. The administrative judge is the person next in rank in Abuja, at the Abuja Judicial Division of the Federal High Court. So that's what certainly is going to play out. But you see, you ordinarily, when a matter is being assigned to a judge, you don't go to the person assigning the matter does not need to discuss with the judge whether he will take it or not, because no judge is allowed to pick and choose which matter he will handle. The Chief Judge, or if he allows the administrative judge, will simply assign it to any judge he thinks should handle it. And that judge will go ahead with the matter, unless he has a compelling reason not to do so, for which he will get back to the chief judge or the administrative judge, whoever did the assignment, and tell him, look at why I wouldn't be a correct person to do so. And the only reason by my judgment that the chief judge or the administrative judge may want to look at is if there is, if that the second of the twin pillars of natural justice, that is, nemo juris in propria causa sua, whether it could come into play in such a matter. Either the judge has any relationship with the accused person, or the judge has, if there's any form of relationship, that's what could be listened to. Because in such a state, it is very, well, human beings. It's difficult for such a person to dispense even-handed justice without fear and without favor.
Now, how long does Kanu need to wait to get justice in this whole trial experience he's having? It's now going to move from one judge to the other. So how long does he need to wait to know how this will end? And will it ever end? Or will it continue as a bouncing ball?
There are two reasons that make it very clear that this matter will never end until and unless the president wants it to end. Two reasons. One is that the charges against him are unsustainable. It is doubtful whether any court of law in this country can convict Kanu of any of those counts. It is very doubtful. And then, because of that, all the state is doing is just to continue to keep Kanu in detention. So that, because you can't talk of releasing him unless the matter is concluded and judgment given. Because they already know what the judgment is likely going to be, they just decided to continue to keep him in detention. Each time they will change the charge. Each time they will change the charge. 5 years have gone by and the trial has not commenced. Even before Justice Bitanyanku, before even assuming she didn't recuse herself yesterday, judgment hasn't taken off. Trial had not taken off. Now, if trial takes off, you will now know that there will still be a lot of time that will be taken before proceedings are concluded, before you begin to talk about judgment. So now the thing is going to another judge. Of course, it's going to commence de novo. It's going to start afresh, although even before Nyaku, nothing had taken place. That is because all they want is to keep him perpetually in detention, because there's nothing against him.
So how will keeping him perpetually in detention continue to affect the Southeast? Yes, a lot of the governors are saying we don't have Monday sit at home in our states, but you and I know that people still don't move around the way they ought to in the Southeast on Monday. Do you think that Kanu regaining his freedom will solve all this problem? And how will he regain his freedom if his case isn't being handled by anyone as we speak?
To start with, it is very doubtful whether even when Kanu regains his freedom, whether the Southeast is going to totally come back. That is, normal life will totally come back in the Southeast on Mondays. It will, ultimately, but it's going to take a lot of time, even after Kanu is released. Because that sit at home has even gone beyond Kanu. It's no longer within Kanu's control. It's no longer within the control of IPOB. It has gone beyond their control. It has now gone into the hands of hoodlums, who now take it as excuse to wreak havoc, murder people and take their vehicles or take their belongings, and they do all manner of things. So I don't see that if Kanu is released today, that sit at home will immediately cease. Of course, sit at home by the laws of this country and by the laws of the various states is illegal. So that what is important is for life to return to normalcy. If life does not return to normalcy, then it will be exceedingly difficult for you to simply dismiss it with a wave of the hand. Of course, I agree that sit at home destroys the economy of the Southeast, destroys the finances or the individual finances of the Southeasterners, people that live in the Southeast, and is generally not good for anybody. So any person that means well for the Igbo nation should do everything within his power and within his ability to ensure and to see to it that that sit at home is consigned to the trash can of history.
So where does this leave IPOB, the indigenous people of Biafra? As this continues, it looks like IPOB, with all the factions we have seen, it looks like it has withered in its influence in terms of how it used to command listenership or even the attention of a lot of the people who were in the Southeast listening to things they were saying. Based on what we know now, IPOB has splinter groups that are not quite clear as to what their ideology would be.
I agree with you. They have a lot of splinter groups, many of them faceless. You don't know if they have a spokesman, you don't know anything whatsoever. But they keep talking and talking. And when, because Nnamdi Kanu, I think it was the only one sit at home that IPOB declared. In respect of, because of the detention of Kanu. But after that first sit at home, IPOB said, we are no longer interested in sit at home. Sit at home should end, and everybody should go about his normal duties on Monday. Because even Kanu himself from detention said he didn't want sit at home. Because sit at home damages the finances of the Southeast, damages the finances of the Igbo nation. And the reason why Kanu said that the reason why he's fighting is for the good of the Igbo people. So nobody should use him as his detention as an excuse to now deal with those persons, that is, damage, destroy the economy of those people he's fighting to protect. And he said from detention that sit at home should be ended. And even after he said it, and the IPOB has continued to repeat it, they've continued to drum it into everybody's ears, and yet sit at home persisted. And those hoodlums who have been nudging on that sit at home, they have continued to make life hellish for the people of the Southeast every Monday. If you are seen on the road, it's just recently from 2000 last year in Enugu State. I'm not talking of the other states. Soludo has been battling with them for some years now since he went into power, and the boys appear to be overpowering the state paraphernalia there. But since last year, we seem to have had a bit of quietude in Enugu State, because the governor of the state, Peter Mba, put his feet on the ground, and not just did he say it, he also matched this words with action by equipping the police more, and the police have stepped up surveillance and monitoring, especially on Mondays, to ensure that nobody is disturbed if you are going about your normal business. Well, I think that in no time, sit at home may be consigned to the history books in the Southeast, especially in Enugu State.
So I mean, if you have a crystal ball, do you see Kanu regaining his freedom anytime soon?
It's only President Tinubu that can honestly, in all honesty, give an answer to that question. They can wake up one morning and tell you, see, it's political expediency that will release Kanu. They can wake up any morning and tell you that, and tell the Tinubu can wake up any morning and tell the Federal Attorney General, Minister for Justice, to enter nolle prosequi against Kanu. And he will simply write the judge. If it's not, if the matter is not coming up, he will just appeal to the court to resume sitting, and he will enter nolle prosequi, and that will be the end of the matter.